Hello, good afternoon. Welcome to Extracting the Raw Potential of the Cannabis Industry. Hello, I'm Steve Levine, partner, executive board member, and leader of Husch Blackwell's national cannabis practice. Before we begin, I'd just like to cover a few housekeeping items. At the bottom of your audience console, there are a few multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed, or if we run out of time, it will be answered later via email. A PDF of the presentation is also available in the resources folder. This program has been approved for continuing legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That's it for all the housekeeping items. Let's go ahead and get started with the program. Today, joining me is Alyssa Samuel and Stacy Kaysen. Alyssa is also an attorney in our Husch Blackwell's cannabis team and focuses her practice on corporate transactions and regulatory advice. She began cannabis work when the industry was very small. When Alyssa first began to assist growers and providers, Colorado was just beginning to navigate the regulation of cannabis. She now helps clients of all sizes navigate the complex and ever-changing cannabis industry. Stacy is the Chief Executive Officer of Planetary, which are natural USDA organic CBDA products extracted only with water. After witnessing abuse of opiates and chronic pain firsthand, after 15 years in the medical field, Stacy made it her mission and passion to find a healthier alternative and bring the highest quality product to market. I'll first start off that this is a very challenging topic, very much talked about in the industry. What we're really trying to accomplish today is a discussion of the interplay between the industrial hemp and marijuana industries, the benefits of introduction of hemp-derived cannabinoids and industrial hemp products into the regulated marijuana market, as well as the distinctions in how jurisdictions are regulating this entire assimilation. The discussion will touch on the varying work of entrepreneurs like Stacy in the market, who are rapidly advancing our knowledge surrounding the isolation and use of cannabinoids and the corresponding regulatory developments. So I'll go ahead and start off with trying to give a general overlay of the federal Farm Bill and how it relates specifically to extracted cannabinoids. And then we will move on to the DEA's recent interpretation, and then talking about both state-specific regulation of CBD and other cannabinoids, and then ultimately how these cannabinoids can be introduced into a regulated marijuana market. December 20th, 2018, our former president signed the 2018 Farm Bill into law. This Farm Bill replaced the Agriculture Improvement Act of 2014, which will expire on January 1st of 2022. It's important to note that the 2018 Farm Bill, in conjunction with the Continuing Appropriations Act, provided that states and institutions of higher learning can continue under the authorities of the Agriculture Act of 2014 until 2022. Due to this extension, many states have actually decided to remain under the 2014 Farm Bill and have rescinded previously approved plans by the USDA. The 2018 Farm Bill does incorporate a bipartisan support that fully legalized the production of hemp. And we'll get into really what that definition is and how the implications of that definition have impacted extracted cannabinoids. Really prior to the 2018 Farm Bill, the federal law regarding industrial hemp was a patchwork of statutes, regulations, court decisions, and really hemp remained prohibited under CSA's definition of marijuana. As such, the domestic production and commercialization of that crop was generally prohibited. But the 2018 Farm Bill really excluded hemp from the definition of marijuana under the Controlled Substances Act and declared industrial hemp is no longer considered a Schedule I substance. Specifically, as the definition here is on this slide, you can see that that industrial hemp is defined as cannabis sativa L with any part of the plant, including the seeds thereof and all derivatives, extracts, cannabinoids, which is important to note, isomers, acid salts, and salts of isomers, whether growing or not, with a delta 9 THC concentration of not more than 0.3% on a dry weight basis. So functionally, what does that mean? Industrial hemp containing less than 0.3% THC on a dry weight basis has functionally been removed from the CSA, really clearing the path for industrial hemp plants to be grown domestically, as well as imported compliantly with all applicable laws. 2018 Farm Bill decriminalized production and use of hemp and hemp-derived products such as seeds, oil, CBD oil, fibers, papers, etc. There were some interim rules that were proposed by the USDA. We're not going to cover those here, really, because we now have final rules, but also the interim rules were really released with little fanfare. Well, I'm not going to go into the rules. They received well over close to 6,000 comments for how hot hemp is destroyed and all the way to DE certified labs. The final rule came out just recently, on January 15th of 2021. These interim rules, the interim final rules rather, I've really clarified some of the concerns, but there's still a lot of desire out there for what the USDA can do from a regulation perspective. Just to give some flavor of what's in those final rules, harvest windows have been expanded for collecting samples for testing, for purposes of testing. There's better sampling flexibility with respect to when and how samples are taken, depending whether from the stem, the terminal bud, or the central cola. Testing, despite the USDA's acknowledgement that there's not enough DEA registered hemp testing facilities, the final rule does require that these testing facilities become DEA registered. They're just giving a little bit more time for those testing facilities to be able to handle the actual DEA registration. The final rules also expanded the no longer needing the use of a DEA registered reverse distributor. The final rule also incorporates additional disposal methods, including options for dealing with non-compliant plants or hot hemp. This has really sort of helped in ways for farmers to remediate non-compliant crops in order to minimize financial risks associated with the loss of investment in their harvest. Lastly, increased negligence threshold. The negligence threshold was increased from 0.5 to 1% of THC. This really allows for a little bit more flexibility and not such a stringent threshold to allow producers that potentially grow something that's over 0.3% THC to have a little bit more flexibility to not necessarily be deemed to have a negligent violation. For those out there that are growing industrial hemp, it's still a lot of science that needs to come. There is a lot of challenges with respect to making sure that the genetics are actually what people think they are. And so I think this has given some flexibility there for farmers. So what does the Farm Bill do? As we talked about, it does remove hemp from the list of Schedule I under the Controlled Substances Act. But there's still a lot of clarity and regulation that is really not flushed out enough with respect to the Farm Bill. It does provide that states and local government can provide additional regulatory provisions and restrictions. There are still dangers with respect to interstate commerce, and that multiple states have different rules and thresholds that are allowed in those particular states related to THC thresholds and the like, and really doesn't remove any of the regulatory powers of other agencies, the DEA, FDA, FTC. We're not going to get into what's going on in the FDA or FTC for purposes of this webinar. But my colleague Alyssa will talk a little bit about the most recent guidance that came out from the DEA and how that applies to what is going on with respect to extracted cannabinoids. What I think is important to also understand is that, we have this federal overlay, but there is still not necessarily strict compliance with all of our states related to the 2018 Farm Bill. And so I think the best way to sort of illustrate this non-compliance is to show sort of green, red, and yellow. The green states are those where the USDA has approved a state plan where hemp can be grown legally in that state. These farmers can grow, sell commercially, and that's reflected in a majority of the states that you see here on this map. The yellow states are states that have submitted USDA plans but have yet to receive approval. As such, really any farming that's going on in those states is technically not in compliance with the 2018 Farm Bill. And then we obviously have a lot of these red states that have either chosen not to submit a plan or have otherwise decided to stay under the 2014 Farm Bill for purposes of the 2021 harvest cycle. And so all of the things we're going to be talking about, it's really challenging to get into every single state's laws regarding the cultivation and production of industrial hemp. But I think it's very important for us to acknowledge that there's a lot more to be coming with respect to state law and also the federal overlay of how hemp is processed and developed. With that, I'm going to turn it over to Alyssa Samuel to talk a little bit about the more recent guidance that we received from the DEA in 2020, which was met with a variety of different fanfare from outlawing varying status of the industrial hemp business. And I'll let her take it from here. Thanks so much.
Thank you, Steve. So as of right now, one of the biggest threats to the CBD industry as we know it to function is the interim rules that the U.S. Drug Enforcement Agency, the DEA, promulgated in August of 2020. And the rule was in response to the 2018 Farm Bill and in anticipation of the final rules that we just received in January. Pursuant to that rule, the DEA stated that the definition of hemp does not automatically exempt any product derived from a hemp plant, regardless of the delta-9 THC content of the derivative. In order to meet the definition of hemp and thus qualify for the exemption from Schedule 1, the derivative must not exceed the 0.3% delta-9 THC limit. So what that effectively means for the CBD industry is that while you can process hemp, depending on how you process hemp into CBD, potentially any of the intermediary products that you may create in that process could potentially violate the Controlled Substances Act, and you could be subject to USDA enforcement. Following the release of this rule, there were several lawsuits filed, and these interim rules have received to date record numbers of comments for how this could potentially be implemented. We do not have final rules yet, and it's been quite some time since August. There was some hope that the final rules for the Farm Bill would provide some sort of clarity with respect to this, and it did not. So as of right now, we're closely monitoring this, but this stands to be something that could really change the legality of CBD operators in the US. The other way that the DEA or federal law can impact the things that we may create out of industrial hemp is the Federal Analog Act. And the Federal Analog Act is a part of the Controlled Substances Act that states that a controlled substance analog shall, to the extent intended for human consumption, so it needs to be intended for human consumption, be treated for the purposes of any federal law as a controlled substance in Schedule 1. And then the definition provides that, except as provided in subparagraph C, the term controlled substance analog means a substance, the chemical structure of which is substantially similar to the chemical structure of a Schedule 1 or Schedule 2 controlled substance, and has a stimulant, depressant, or hallucinogenic effect on the central nervous system, substantially similar to or greater than the controlled substance, or with respect to a particular person, which such person represents or intends to have that effect. So what is an analog? Stacy, I'll turn this over to you so you can give us a chemical definition of what an analog actually is.
Yeah, so analog is a broad chemistry term that encompasses any compound being similar to another one, either physically, chemically, or functionally. And homologue, which you mentioned later, is a type of analog, but an analog is a broad term. So we have a few different analogs within the hemp plant, and I think you'll get to some of those. But it just means they're similar, and they can be similar either in function or in structure.
And the case law that we have surrounding the Analog Act and this type of prosecution can be extremely vague. So in the cases that we've seen in the last 20 years, a lot of times there will be competing experts. Some may say that it's structurally similar. Some may say that it is not substantially similar to the substance. So it can really depend on a trier of fact determining whether or not it is an analog from a chemical stance. And then that's not even considering the functional stance. So it needs to have a similar function. So in creating a compound that may have a similar structure, if it doesn't have a similar impact, like for instance, right now there's a lot of talk about THCV. Some people think maybe that's a weight loss drug and it may have a completely different effect than THC. Under this definition, that would not be an analog because it's intended to have a completely different effect. The other thing this case law sort of hinges on is a knowledge element. So I chose sort of three seminal cases in this area that have continued to define the elements that would be needed for there to be a substantial risk of prosecution under this act. In 2002, United States v. Washam, this case challenged the vagueness of the statute. So the defense took the position that it's unconstitutional for you to be prosecuted for something that you were unaware that you could be violating, and that this statute was unconstitutionally vague and left itself open to arbitrary enforcement. The court disagreed and upheld the conviction. In McFadden versus the United States, that challenge was again made. It was again upheld, but the court inserted a knowledge element to it. So that case was a case about bath salts, and they looked at the conduct of the defendant in contrast to the conduct of the defendant in Washam. So in McFadden, the defendant was selling bath salts. Once he realized that the bath salts were similar to a controlled substance, he stopped. So the holding in that case was his conviction was vacated. The government must prove that a defendant knew that the substance with which he was dealing was a controlled substance, even in prosecutions involving an analog. So at the time he was doing it, he didn't know that he was doing it or have the intent to do it. Where in United States v. Washam, what distinguished that case was the conduct of the defendant, and that is what the government looked to. The government said, you clearly knew that you were violating the Controlled Substances Act because you felt that it was appropriate to hide it, deceive officials, and then mark up the prices in sort of a black market situation. So your conduct very clearly showed that you had the intent to create something that had a similar effect to a controlled substance and then treat it as such. So the third case is a much more recent case, and that was decided in 2018. And this case further expanded on that knowledge element. And it basically said, yes, you need to have knowledge that this is a controlled substance, but you do not need to have knowledge of what controlled substance it is specifically, just that whatever you're creating and selling intended for human consumption, similar to a Schedule 1, Schedule 2 substance, and similar to that function, as long as you know that it's similar to something that is controlled under federal law, that will satisfy that. That will satisfy that knowledge. And that will become important as we get into talking about certain compounds like Delta 8 in our next few slides. So one of the most well-known compounds is CBD and CBDA. And so this is really Stacy's specialty. She has a fantastic business in selling these products and producing these products. And so we're really lucky to have her here with us today so she can tell us a little bit about how she produces CBD, CBDA, and what the difference is between CBD and CBDA, as well as what the difference is between those two compounds and Delta 9.
So the plant actually makes CBDA. So the common misperception that we hear in the industry is that CBDA is a minor cannabinoid, or that it's unstable, or I've never heard of it. And the cannabis plant, and we're specifically talking about on the hemp side of the industry, the most prevalent cannabinoid created by the cannabis plant is CBDA. You hear of CBD, but that is something that happens after harvest. So the plant has its own biochemical process. CBGA is kind of the mother cannabinoid that starts with, and then through CBDA synthase, CBDA is created, and that's, like I said, the most prevalent cannabinoid in the hemp plant herself. And then after harvest, through either heat or through chemicals, and most often both, that becomes decarboxylated, which means the carboxyl groups is removed. The bond is broken through either heat or a protic solution like ethanol. And then the byproduct of that chemical reaction is CO2, which is sort of the off-gassing that people talk about. But the two most common types of extraction on the market are CO2, supercritical CO2, which uses really high pressure to concentrate the cannabinoids and other materials from the plant. And then the other one is ethanol. So that protic solution of ethanol is used. The plant is soaked in that ethanol, and from that, the cannabinoids are solubilized and come out. Most, I think both of those types of extraction have basically 3 steps, sometimes 2. So the first step is crude, and they come out what they call a crude oil. And it is typically 50 to 60% cannabinoids, and the balance of that is other plant materials. And it's also of note that in that will come the pesticides or heavy metals or any of the other materials that may be in the plant or in the soil. And whereas hemp is a fantastic remediator of soil for environmental concerns, when you're concentrating on extraction, those will come out in that crude oil as well. And then there's a stage called distillation that refines it a little bit further, and it's going to remove some of the other plant materials and have a greater concentration of CBD. And by then it has decarboxylated into CBD, and that'll be the most prevalent compound at that point. And both of those processes, heat, pressure, and ethanol is used because for most, and I don't know every single processor's unique details, but for most CO2 processors, they then use ethanol to clean it up and get it to a more like refined, concentrated form. And then those that choose can take it all the way to an isolate. The term is isolate. It stands for an isolated compound. So you're getting to that one molecular compound of typically CBD. So with that process, they're eliminating other cannabinoids that grew in the plant, and they're isolating it down to just the one CBD. And that is done usually through solvents. And so the cannabinoids are soluble in the solvents, and then they're distilled down, and it's typically super freezed, where the solvents are then evaporated, and you're left with this refined, isolated compound. And again, there's, I'm sure, nuances in each individual processor and how they do it, but at a high level, that's the processing for most. And then we are kind of the oddball in the industry. So my company, Planetary, does water extraction. And so we keep the cannabinoids in the raw form that they're grown in the plant. So the plant has CBDA, and then typically THCA, CBGA, maybe CBDVA, or there's a few other of the A's, and the A stands for acid. So the A at the end of CBDA stands for acid. So that's, like I said, the form that it's grown in the plant. When we do the water extraction, all of those cannabinoids come out in the ratios they were grown in the plant, so a full spectrum format, and it stay in their acidic form. We don't use pressure or heat or solvents, so none of those things are chemically changing it. So it does stay in that stable CBDA format, which means it's a different molecule and it has a different effect on the body. And we may not want to go much into the bioavailability and potency and the effect in the body, but just know that it is a different molecule and it does have a little different effect in the body. And when we look at the chemical structures here from CBDA in the plant, there's the decarboxylation where carboxyl group is broken off and you have the CBD molecule. We also have on this page the delta 9 molecules just to show you kind of the comparisons. And those are different molecules. Alyssa was going into the analogs. So there's a difference between truly the different cannabinoids, like from CBDA to delta 9 THC. And then there are the analog formats where they are changing in between.
And that brings us to THCA, which is more similar in structure to THC. And Stacey, you also are familiar with how to produce THCA and the decarboxylation process that creates THC from THCA. Could you tell us a little bit more about that?
So very parallel to the way I described CBDA to CBD, the plant produces THCA. So the marijuana plants, and that's, they're all the cannabis plants. It seems more of a legal definition, but we'll say the marijuana or the caffeinated side of the industry, where their THC is in higher levels. It is still THCA. And what you're doing when you smoke a joint, for example, is you're heating it. If you were to just eat that same bud, it would not have the same effect. But by heating it, you're decarboxylating it into THC, which is the psychoactive component. So it's the delta 9 THC very specifically that causes that euphoria, the high, the psychoactive component for the marijuana plant. And our process also keeps THCA in its raw natural state. So you mentioned briefly the interim products. So we talked about crude and distillate, and those interim products through extraction are concentrated. And so whereas the plant had less than 0.3% of THC, as you concentrate through processing, that number usually goes way up. And so that's where it does become a bit of a gray area with the law. But in our process, specifically in the water extraction, it stays as THCA. So it's not the delta 9, it stays as the THCA.
And is that because it's not heated?
Correct. And even in the absence of heat, so it's not only heat, so there's a time and temperature consistent model. So a little heat for a long time or a lot of heat for a short amount of time can have that reaction. But even with cold extraction, where they're not applying heat, but they are using ethanol or another like protic solution, that solvent does cause a decarboxylation, which starts immediately and continues throughout. So even if it's an ethanol extraction with cold, it will over time, starting immediately and gradually, decarboxylate both CBDA and THCA.
So our next compound that we wanted to talk about was delta 8 THC, which is gaining a lot of popularity right now. Stacey, what exactly is delta 8 THC?
So delta 8 is a naturally occurring cannabinoid. It's technically produced by the plant, but in teeny tiny amounts. So you can find it in hemp plants, just in very small amounts. So then what processors are doing is extracting that and then finding ways to converting basically from the CBD to delta 8, and then concentrating the existing delta 8 in the plant. So it's at a high level, it's done with toluene or PTSA. So very acidic solvents are used to create delta 8. Because it's new, I think what we don't know yet is what byproducts are produced through this process. If you look at the chemical structures of delta 8 versus delta 9, for those of you who do not have a science background, I challenge you to look at this and compare the differences. So not only is this an analog, it's actually an isomer. So the double bond just moves positions. So Delta 8 has it between the 8th and 9th carbon, and Delta 9 has it between the 9th and 10th carbon. So it's just the position of one of those double bonds. And the reason it's an isomer is just that similar shift. It's actually the same chemical structure, just a different orientation. If you look at it on a 3D model, you would see the different orientation of that bond. But they do have, so not only a structural analog, but they're also a functional analog. Delta 8 has between 50 and 75% of the potency or of effectiveness of Delta 9, but it does cause the same, essentially the same functions in the human body. So it does have psychoactive properties, and it's being studied for a lot of other beneficial properties. But I think it's important to note how similar it is to Delta 9.
And so when we talk about analogs, obviously this is intended for human consumption, but if we look at the other elements to it, it's chemically very, very similar in structure. Mm-hmm. Whether or not that would be enough to create risk under the Analog Act is unclear, but it is much more similar than even any of the other substances that we've gone over today.
Yes.
In effect, it has a more muted effect, but it's still a very similar effect. So would it necessarily be a defensible position to say, well, you'd have to ingest that much more of it to get the same effect? Would that create liability under the Analog Act? That's also unclear. There's also there would also obviously be the knowledge element of, do you have knowledge of those things, and that this should be controlled? And right now, this is all, particularly with Delta 8 THC, it's all very, very gray, and we're not really sure how the government is in various states and at the federal level is going to approach it.
I would add on the Delta 8, there's been some shop owners that were recently arrested for selling Delta 8 products in Texas. And one thing I got a question for you, Stacy, on sort of the availability of Delta 8, just naturally occurring Delta 8. When you say tiny amounts, is there any way to quantify that in a simple manner of tiny amounts? Can you make real products that are derived Delta 8 THC without doing some other synthetic process?
It's now a requirement so our lab is an Emerald certified lab, and now as part of that qualification, you have to test multiple cannabinoids and potency, and Delta 8 is one that has to be tested now. So if a hemp plant has to have less than 0.3% by dry weight of Delta 9, Delta 8 is 0.1 or even less. To be honest, in all of our plants, I haven't seen it register as an amount. So it's been a non-detectable amount or below the level of quantification from what we've seen. I'm certain that there are genetic strains that have higher levels of Delta 8, but it's less than 0.1% from everything I've seen.
Gotcha. So, it seems as though, at least from my perspective, and again, this is just my personal perspective, I'm not the scientist, and I'm sure there are plenty of people out there that have different extracted methods. It seems as though products that have a lot of Delta 8 in them, you can see them on the internet. I get spammed with emails on a regular basis with varying products of Delta 8. It seems like those products are probably synthetically derived Delta 8 from CBD is probably the most likely scenario.
Yes.
Gotcha.
They're synthetically derived. So it's one example is diamonds. So you can have a real naturally created diamond, or you can have a lab grown diamond. They have the exact same chemical structure. The difference is how one was synthetically created, one was naturally created. So if you bought your wife a synthetic lab created diamond, would she know the difference? Would she care? I don't know. That's a personal decision, but that's a kind of a similarity.
Yeah. Well, I think my wife would definitely know, but I think that's a good way to think about it.
Yeah.
So I think we'll move. So we've kind of covered the 2018 Farm Bill. We have talked about some the Analog Act. We talked a little bit about synthetics, right? I mean, I think that's a whole nother conversation, but I thought it was worthwhile to at least acknowledge that that is a potential risk when you're looking at mass producing some, cannabinoids, especially cannabinoids that are related to or analogous to a Schedule I substance. But we'll leave that where that lies. It seems, I think that a lot of things will be coming out over the next handful of months and years about what ultimately people can do with that product. But so now we have all this federal overlay, the abilities to grow and extract cannabinoids from a federally legal substance. And now how does all this relate to the regulated marijuana systems? And it's different. Shockingly, this is not the same in every state. Alyssa and I have pulled off examples of how different regulators have viewed industrial hemp products being introduced into the regulated marijuana system. And so we'll go through those. Again, I'll encourage everybody, to the extent you have any questions, feel free to throw those in the box down there, and I'm definitely monitoring them and happy to try to answer some of your questions live to the extent that you have them. So, in Colorado, while there are lots of reasons to say we're overregulated and not sort of, in kind of problematic in a lot of different ways, we have started the introduction of hemp products into the marijuana regulated system. This is very recent, and so this is now happening here in Colorado, where I'm based. And really, so long as the industrial hemp product, which is a defined term under the Colorado regulations, which is a similar definition, shockingly, to the definition under the 2018 Farm Bill, so long as those products have passed required testing, and that testing is set forth in the regulated marijuana rules, that can be that those products, which include cannabinoids, can be introduced into the regulated marijuana system. So once they're fully tested, they can be brought in. So what does that mean? That means CBD can come in, CBD isolated to fortify certain products, and other cannabinoids. What is also required is that the Colorado industrial hemp operators are also satisfying CDPHE guidance, that the CBD can be incorporated for food and human consumption. What I'll point out, which is just a nuance to all this tangled web that we have to deal with, Colorado is still not a 2018 Farm Bill compliant state, because we have not gotten our USDA plan approved from a growing and testing perspective. And so technically all of our industrial hemp is actually not federally legal. In Colorado, we don't care about federally illegal because we have a regulated marijuana system that nobody cares about that part either. So, not that I see that as a huge legal risk one way or the other. I just think it's kind of interesting. And I think maybe, Alyssa, I'll ask you to kind of explain this a little bit, if you don't mind. Just sort of how the challenges, and going back to Delta 8, and we hear a lot about Delta 8 and how that may or may not be a problem from introducing that into the regulated system in Colorado.
Well, so Steve, if you introduce hemp into the regulated marijuana system and you create Delta 8 from hemp and it is in the regulated marijuana system, then that's absolutely protected and falls under the carve out to our criminal statutes that was created to protect the regulated marijuana system. However, our criminal statutes have a very broad definition of tetrahydrocannabinols, which would potentially include Delta 8 as a synthetic cannabinoid. So in Colorado, if you are not operating within the seed to sale regulated marijuana system and create Delta 8 outside of that system, you would not have that same protection that our licensed operators do. And potentially, dependent on the federal treatment of Delta 8, whether or not that is considered an analog, and under the state's definition, if the state considers the process in which you take a small amount of Delta 8 that's naturally occurring and synthesize it to the point that it's a concentrate in a product, if that's deemed synthetic, then potentially that could also fall under Colorado criminal statutes as well, based on our definition.
Thanks, Alyssa. And so maybe we'll go to the next slide, and you can give us your input on Illinois.
Before we move on to Illinois, I wanted
Sure.
to have Stacy talk a little bit about, because Stacy is a CBD processor who is certified by CDPHE, and she has a little bit of experience, and she's one of the few operators that do have some experience with selling into the regulated marijuana system. And so I think some of our viewers may be interested to hear what that experience was like.
Yes, when it first became legal to do so, we were really excited to sell our products into the dispensaries. And so we met with a group who stated they were the gateway to get into the metric system, which is Colorado's seed-to-sale registered system, and you need the RFID tags, et cetera. So we jumped through the hoops and we followed this group. The cost was 3 times the normal testing cost. So on every batch, we do a full suite of testing. So we're testing for microbials, for pesticides, for heavy metals, residual solvents, and potency. So those 5 tests, we know what they cost at a normal lab. And then it was 3x that to get into the metric system. Part of that expense may have been this gateway person that turns out wasn't needed. So this industry is amazing and wonderful, and it's still emerging, and there are still some, say, opportunistic predator types. So kind of watch out for that. I thought it was still worth it. We'll pay the costs, and we're happy to be in the dispensaries. And what we found is, just from a market and business standpoint, not many people are going to the dispensaries looking for CBD. They're going to the dispensaries looking for THC products. They know they can buy CBD anywhere. So what we found was that, at least in my experience, and I would love it if I'm wrong and someone tells me that, but it does not seem as though there's a demand for the CBD products in the dispensaries. So in my experience, it was kind of a waste of money and time to go down this avenue.
Getting back to, so Colorado has a fairly robust system for regulating our processors, and even some local jurisdictions in Colorado, like Denver, have very specific regulations. We, unlike some other states, can add CBD to food, but we have to follow those regulations. And I know you're CDPHE certified. What was that process like?
So there's an application online, and there are food inspectors that can come out. They do ask for shelf life stability data. So it wasn't terrible. It was just a lot of questions, a lot of proving the sourcing of your ingredients, like I said, shelf life stability testing, and a cleanliness factor. So it's just kind of basic. Make sure you have a pest control plan for any. I think it's the same process as any of the food processors in the state of Colorado.
Thanks, Stacy. And now we'll move on to a couple of the other states that Steve and I thought were noteworthy of mentioning. Illinois has taken probably one of the most liberal approaches to incorporating hemp and CBD products into their system. As of April of last year, they implemented an interim policy that allowed registered processors from any state, or hemp producers from any state, to sell to their licensed cannabis cultivation centers for processing. And so by doing so, those products would be incorporated into their regulated marijuana system. Illinois has both adult use and medical marijuana available. That policy expired as of October 31st, and Illinois recently renewed it. And it's essentially the same as the previous process. It will now expire September 30th, 2021. All hemp obtained can only be used in extracted form for infused cannabis products. So that means that hemp may be imported into the system and processed, but you can't actually sell hemp flower. It has to be extracted and then incorporated into products. Licensed cannabis cultivation centers may procure and or process industrial hemp in the form of distillate or isolate as well. Derivatives must be accompanied by a certificate of analysis showing potency levels for Delta-9, THCA, CBD, and CBDA, which we've talked about all of those compounds. It may be procured from any third party that's a licensed grower and or processor from within the state of Illinois, or any other state with a regulated industrial hemp program. So as long as you have a registration and you produce hemp, it can be sold into this system as long as it has the appropriate testing and analysis attached to it. And the licensed cannabis cultivation centers in Illinois may process it as long as they will need an additional hemp processor's registration that they can obtain through the Department of Agriculture. In Illinois, there's a very different treatment of Delta-8. They don't have the same definitions in their criminal statute. And so right now, it does not appear that there would be the same issues in Illinois that you would have in Colorado. California. And so California has the exact opposite treatment of incorporating industrial hemp products into the regulated marijuana system. So there are some exceptions, like you can use hemp paper or those types of products, but as far as cannabinoids, CBD concentrates, that type of thing, those all have to be procured from a licensed cannabis cultivator within the state of California. So you cannot bring it into the system from outside. It has to be part of that seed to sale system. CBD sourced from hemp can be sold in California. However, there are much more restrictive uses. You cannot put it into food because California has a similar state law called the Sherman Food, Drug, and Cosmetic Law, which is very similar to the federal Food, Drug, and Cosmetic Law. And so in California, you are not supposed to put CBD into food. Some of those products are available, and you will see that. It is not allowed under federal law or under California law. However, California does not have the same prohibition on Delta-8 that Colorado would. So Delta-8 seems to be more widely available in California. So as you can see, there's a really disparate treatment of all of these compounds under different state law. And these different compounds is really different just based on their chemical structure. And sometimes it's the same compound, it's just later on in a process, and that could create a very, very different legal result. Steve, did you have anything else to mention?
No, I don't have anything else to mention on those. I mean, I think what is evident from all of this is that from the federal laws to the existing DEA rules and interpretations to the confusion on what actually is happening from a chemical perspective to the disparate laws that are existing in all of these different states. The big takeaway that I have is it's just not clear, and there's not a great answer to saying, yes, this is how it should be done and this is how it shouldn't be done. There's a lot of conflict between the regulated marijuana world versus the industrial hemp world. The regulated marijuana world has a monopoly on THC, and we'll be frank about it. And introductions of cannabinoids that can be derived from industrial hemp that is impacting the regulated marijuana world is not really acceptable to a lot of people that have been in the industry for a long time. And I think this is sort of the fascinating intersection of these two very different industries that are dealing with the exact same plant. It's just different percentages of cannabinoids, and how all that gets regulated and how all that's going to fit is going to take time. And so there's really not a clear answer. And, one of the questions we received, and I'll try to take these by order because I think we got about 10 minutes left here. The first one is sort of the question being, is a retailer, going to get in trouble for selling CBD products? And the answer to that is depends. Depends on what state you're in, depends on what local jurisdiction you're in, depends on the type of product you're selling, how you're marketing that particular product, the labeling of that particular product. California, for example, if anyone's familiar with Prop 65, you got to slap labels on things if you think it might cause cancer. So there is a multitude of potential risks for selling a product that unfortunately doesn't have a lot of scientific research into it, because our federal government has denied researchers the ability to actually test things for years because of the DEA stance on the fact that it was a Schedule 1 substance. And so, the short answer is potentially, I think you really got to be careful on what kind of products you're putting out there into the retail stream. And, I think that whether it's CBD or Delta-8 or any other cannabinoid, there is going to be uncertainty. I would say there's more certainty in the regulated marijuana market than there is in the industrial hemp market, because in the regulated marijuana world, you can do what as long as your plant's deemed a marijuana plant, you can extract it and create THC products, you create CBD products, and that is all very clear. What is not clear is in the industrial hemp space, where some very new science is coming out on a regular basis to be able to isolate and extract cannabinoids that have different effects, whether it's effects for inflammation or effects for euphoric effects like Delta-8 THC potentially has, to CBD. These are all things that are new and still under a lot of review. And I think the what we're hopefully trying to convey on this webinar is this is going to take time and the help from both the legal side, but also from folks like Stacy, who understand what they're doing, understand the products that they're making, and trying to come up with a regime that allows for everybody to kind of play nice in the sandbox. And so, I guess, Stacy, maybe I'll ask you a question. You're obviously in a world that's gray, and you're selling products in that, and maybe I think it might be helpful to give your perspective on kind of how you navigate that, and where you try to stay clear of, and just from from your own perspective.
It becomes challenging because from a business and marketing standpoint, you want to put on the bottle, this could cure cancer, but you can't, because it's not proven, and that's a claim, and you'll definitely get in trouble for that. So the label itself has to have there's an FDA disclaimer that my attorneys helped me with that says this is not intended to cure, treat, prevent any disease. So that's obligated. You have to put on each label that it contains less than 0.3% of Delta-9 by weight in order to be legal. And actually what I found was the banks are far more stringent even than FDA and kind of the law. So depending on how you're selling, the payment processors that we use online had even more strict requirements. So we kind of had to jump through their hoops and kind of get the guidelines on what to say and what not to say. So that's where you want to say more, because you want to sell your products and you believe in it and you want everyone to hear how amazing it is. And your hands are tied a little bit in what you can say, but definitely have to have the less than 0.3%. Definitely have to list your ingredients and have the FDA disclaimer on it.
We had a question from Kevin Galligan at KMG Law. Could specific cannabinoids or CBD oil be used and listed on label as an inactive ingredient and therefore avoid being considered a drug and allow the product to be a supplement? I think the problem with that, I don't know that it would necessarily change the landscape in that supplements would still be regulated. But as it stands right now, the FDA has issued guidance that they intend to regulate CBD. So whether or not you list it as active or inactive, if it's within the product, it becomes part of the purview of what they intend to regulate.
Okay. We have a question from Rich. What about licensed operators who are converting CBD isolate into Delta-9 and adding the output to produce amazingly high yields? I won't touch on the legal part where it gets into the metric system, because that is going to be state dependent. I think we talked about if it's in Colorado, it has to be registered through the metric, but converting CBD isolate into Delta-9. So it's the same process, actually. So it's the toluene, it's super acidic, and almost no chemical process is truly clean. So there's a lot of byproducts that probably aren't tested for. It's the same process with Delta-8 and Delta-9, and they usually they're made together. So We're also finding now that some of the local labs, some of the hemp testing labs will not test Delta-8 products because they're not sure how they're made. And so they're not sure of the byproducts, and they don't want to put their name on any of the products. So as far as you can make Delta-9 from CBD, it's definitely a chemical process, not perfectly clean, but it can be done. And then the Delta-9 component is not a gray area. That does have to be in Colorado, the metric system, or other states, the registered marijuana system.
And Rich, the MED has a science and policy work group that is starting to address this issue that you're getting at. Right now, there is not a specific regulation in place that addresses a specific process, and there is not a specific opinion on it. But there has definitely been some dialogue about how that could impact the industry.
Yeah, and what I would say on all, some of these questions regarding sort of the input of Delta-8 is, once again, the industry is just ahead of the regulations, right? And so the regulations might be silent on a lot of these things. And what I think we try to, one, be a little bit thoughtful about, but what I always try to talk to clients about when thinking through some of these gray areas is, think about the people who have gotten in trouble in this industry are the ones that have pushed that gray area a little bit. You look at Sweet Leaf here in Colorado. You look at what Ease was doing out in California with respect to taking credit cards and some of those issues. Small companies, big companies are making mistakes, and a lot of people are getting in trouble for them. And what the hope is that the industry can come and really educate our regulators about what's going on, what they're able to do, so we can fit a regime that actually works with it. Because if not, I'll tell you, there's plenty of people in the DEA and the DOJ that are looking at this Delta-8 issue, and they view it very differently than the industry does. And they're going to view it as a synthetic potentially, and they're going to potentially view it as an analog, and they are going to take an aggressive position because in their view it's THC and we don't care, and if it's 75% is effective, doesn't matter, and they're going to look at people and prosecute them. I mean, I don't know how else to sugarcoat it. So it's going to be really interesting to see what goes on from there. We got another question about we talked a little bit about banks and banking and sort of what to do about being approached by a hemp or marijuana business. That's a long conversation, and for the person that asked that question, I'll follow up via email separately and try to address that. So I think we just have a few more minutes left. I guess I'll just ask Stacy or Alyssa, is there anything else that you wanted to raise on this? If not, I think I'll give us a conclusion here and let everybody go back to their day.
Sure. I was just going to we had one more question from Lisa Pittman. Do you think the knowledge mens rea element is different for someone intentionally manufacturing a potential analog, such as Delta-8 from a retailer who is simply relying on a COA and representations of distributors and wholesalers? And I think that would entirely depend on what those representations and distributors and wholesalers represented. So I think that definitely would impact that mens rea element. Thanks, Lisa.
My closing remark would be, I think a lot of us don't love regulations, and the idea of the government's coming down and tons of regulations could be a negative connotation. And what I think would be helpful in this industry is to give consumer confidence. I've talked to so many people who would love to try, this healing plant medicine, but they're afraid of, will I get high? Will I get in trouble? Is it regulated? Someone make this in their basement? Is it going to have tons of solvents or heavy metals in it? Because some do. So having some guidance, having some regulations will help, I think, the industry as a whole translate to consumer confidence. And so if you're a consumer and you're interested in some CBD type products, check the labels, check for testing, check for certifications and verifications that what you're buying has been quality tested.
Great. Thanks, Stacy and Alyssa. So, you know, some of you might have in pre-COVID days come to our office where we hosted these types of sort of roundtables of trying to explore challenging and difficult topics that are, you know, maybe not as widely discussed within the industry, and trying to get really as much feedback as possible. Unfortunately, you know, our online systems only allow for sort of questions and not a lot of back and forth with our guests. And really want to say thank you for everybody for joining today. Really hope that it was informative and helpful to your organization. Really appreciate feedback. You know, we're doing this for the benefit of the industry, both on the industrial hemp and marijuana side, and really encourage and want to continue the ongoing dialogue of how we all can frankly be better. And so just as a reminder, the program was approved for continuing legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. I mentioned feedback. You know, love to hear your thoughts on the survey of how we can be better and make things more useful for you going forward. And then lastly, I just want to encourage you to join us on our next webinar, which is March 18th at the same time at noon. We'll hopefully get an update from the Colorado MED on its rulemaking and how some of the issues that we talked about today might be impacted in the Colorado regulatory regime. So this concludes our webinar, and thank you very much.
Thank you.
Thank you.